My last example deals with the classification of the employer and deals with whether the plaintiff was a casual worker and therefore fell within the exclusion for coverage that was in the Act that we talked about at the beginning. In this case, the plaintiff was a passenger on the bus, but she was there because she was a bus monitor for disabled passengers that the bus service was hired to transport. During a particular trip where the plaintiff was a bus monitor, the bus collided with a pickup truck, the plaintiff was injured. The bus owner who employed the plaintiff filed the appropriate report forms with the WSIB, and the WSIB opened a file. It's not expressly set out in the decision, but it appears that the plaintiff did not file their forms with the WSIB and did not apply for WSIB benefits, and shortly before the 2-year limitation period, she started a court action against the owner of the bus. And, of course, the owner of the bus brought an application for a declaration before the tribunal that the right of action was taken away. Now, at the tribunal, the plaintiff said, number one, she was a casual employee and therefore exempt from the Act. She said that she didn't work regularly, that she was only called in when needed, that she was only part-time, and that she only did this on a seasonal basis. She, in fact, had 3 other jobs which provided, took up the majority of her time and provided her with the bulk of her income. Now, her second argument was that the job that she had was to be a monitor of disabled students on the bus and to attend to their needs while being transported, and that this was akin to a student-teacher relationship, and therefore this fell within the exemption of coverage in the Act for educational work. The tribunal held that while the work may have been casual, it was not exempt because of that, because this exemption has a double-barrel criteria. It has to be casual employment, and the casual employment has to be of a type that's not within the ordinary purpose of the employer's industry. And since being a bus monitor was part of the employer's industry of transporting students, even though she was casual, she didn't meet the test for that exemption. Her second argument failed as well. They said the true nature of the job was to load and unload passengers and ensure their safety, and to allow the driver to focus on their driving. The tribunal held that there was no special training needed, no certification needed to do the job, so that the job was to assist in transportation, not to educate and to provide life skills to the students. And they held that her right of action was removed.